You may have noticed that we have reset the countdown to applicability of the DOL final rule on dolfiduciaryrule.com. We have added 60 days to reflect the delay announced by the Department of Labor.
That's right. Now on June 9th, we will have a lot of new fiduciaries. I'm Carol McClarnon, and this is Allison Wielobob, and today we are going to talk about what it means to be a fiduciary beyond compliance with the BIC exemption. We have been given an opportunity to take a step back and plan.
Starting June 9th, the final rule will determine who is an ERISA or an IRA fiduciary. No changes were made to the fiduciary rule when it was delayed by the Department of Labor. However, if you're a new fiduciary as a result of the rule, your relationship with your customers will change. Think of it this way: if you were concerned about complying with the BIC exemption, you probably need to be concerned about becoming a fiduciary on June 9th. This is a heavy lift.
That's right, Allison. Fiduciaries are subject to the full range of prohibited transactions under the Internal Revenue Code and ERISA. This is a large list that covers a number of everyday business transactions. Fortunately, there are a number of exemptions, compliance of which will get you out of the prohibited transaction restrictions. It's just important to know what those are. The 60-day delay provides us time to get out of the BIC weeds and prepare.
Right. The impartial conduct standards will apply beginning June 9th. That's a lot to think about. This means that fiduciaries under ERISA and IRA fiduciaries are required to act in their customers' best interests. They have to avoid making materially misleading statements to them, and they may receive no more than reasonable compensation. ERISA fiduciaries are subject to a vast regime of duties and responsibilities. In addition to those we've already discussed, they are subject to prohibited transaction rules regarding conflicts of interest.
And ERISA fiduciaries, in addition, are subject to duties and obligations that come in through the statute itself. And for this purpose, keep in mind that an ERISA fiduciary can be a fiduciary of a SEP IRA or a simple IRA. Activities such as delegation of duties may in some cases now be subject to fiduciary standards. A fiduciary should be aware of its co-fiduciaries and parties in interest to the plans that it serves in order to avoid inadvertent prohibited transactions. In addition, ERISA itself provides for private rights of action against ERISA fiduciaries. So an ERISA fiduciary is subject to claims even without the BIC exemption.
The good news is that if you know your obligations and you prepare, it can go a long way. So procedurally, where we are with this is that the Department of Labor is reviewing the substantive justifications for the rule. So ultimately, what will happen with the rule remains to be seen.
Thank you for listening. If you have any questions about your new fiduciary obligations, please feel free to contact either one of us. For information on the fiduciary rule, you may go to dolfiduciaryrule.com, where we will continue to update our resources page, including information on the litigation challenging the rule. And finally, for general legal news, you can always go to Eversheds Sutherland.com. Thank you.